Please be seated. Good morning, ladies and gentlemen. Go ahead and get yourself situated with your notebooks if you're taking notes, and I'll ask the state to call its next witness, please.
Thank you, Your Honor. The state calls Josh Ward.
Good morning, sir.
Good morning.
Would you please raise your right hand? Do you solemnly swear that the testimony you're about to give to this jury will be the truth and the full truth under the penalties of perjury? Please be seated.
Good morning, sir. How are you?
Great, yourself.
Doing well, thanks. Can you please state your full name and spell your last name for the record?
Joshua Paul Gagnon, Gagnon.
And Mr. Gagnon, how are you currently employed, sir?
I am employed full-time with Frisbee Memorial Hospital for their paramedic service.
And how long have you been with Frisbee Memorial Hospital Paramedic Service?
A little bit over 4 years.
4 years. And what are some of the duties and responsibilities that you perform as a paramedic with Frisbee Memorial Hospital?
We respond to all emergent and non-emergent calls within the city of Rochester for emergency medical services, as well as assisting outside communities within the greater Rochester area for pre-hospital medical care.
Mr. Gagnon, can you just describe briefly how your experience was to become a paramedic, what types of training and education you had?
Paramedics programs are 2 years, the associate degree programs, the war certificate programs, it's intensive training, that includes clinical hours both in the hospital and out of the hospital with different various aspects of the medical realm for emergency care.
So you do a 2-year program, and did you graduate from that program?
I did.
Okay, and after you do the program, do you receive any other training to become a paramedic?
There's on-the-job training as well as continuing education that's required every year to maintain a license.
So you said that you work out of Frisbee. Where are you specifically stationed?
The emergency department at the Frisbee Memorial Hospital.
Okay, so can you just walk through generally, a call comes in, what do you do?
When we're dispatched by the local police department, which is Rochester Police Department, we immediately respond in our ambulance to the dispatch address and give them information from our dispatch center.
Do you typically receive a little bit of information while you're on your way to the scene?
We do. We're dispatched with the type of call and any pertinent information obtained by 911.
So, Mr. Gagnon, I want to turn your attention now to June 12th of 2017. Do you recall if you were working that day?
I was.
Okay, and again, just where were you working that day?
At Frisbee Hospital for the paramedic service.
At some point, did you receive a call dispatching you to the Planet Fitness in Rochester, New Hampshire?
I did.
Let's start with, do you recall approximately what time you were dispatched to that area?
I do not recall the time exactly. It was later in the evening.
Did you read a report after this incident happened?
I did, sir.
Okay, and would that report document what time you were dispatched specifically?
Yes, sir. It's the exact time reported by the police department.
Okay, do you think seeing a copy of your report would help refresh your recollection as to what time you were dispatched to Planet Fitness?
Yes, sir.
This is page 1. So just have you look at this and read that to yourself, and then I'll ask you a question, okay? Seeing that report help refresh your recollection as to what time you were dispatched to the Planet Fitness?
Yes, sir.
Okay, what time was that?
It's 10:07 p.m.
And I should have had you look, but you recall exactly what time you arrived at the Planet Fitness?
It's 10:11 p.m. Approximately 4-minute response time.
4 minutes. Okay. And you said that typically you get some information when you're on the way to a scene. Did you get information in this case?
Yes, sir.
What information did you have as you arrived?
Objection. Hearsay.
I'm not offering it for the truth, just to the extent that it impacted what he did on his way to the Planet Fitness.
So the objection's overruled, and let me just explain to the jury. Typically, when a person is testifying as to what another person told him or her, that's known as hearsay. I'm sure you've heard that term before. What's not hearsay is when a person is testifying to what another person said to them. It's not being offered to prove that what the other person said is true, only that the person said it and what actions the witness may have taken because the person said it. But it's not being offered for its truth, so you're not to take the statement as true. All right? Go ahead.
So, Mr. Gagnon, did you receive some information on your way to Planet Fitness?
Yes, sir.
What information was that?
Was dispatched for a female that was assaulted with possible injuries.
So you said you arrived at about 10:11 p.m. and what do you observe when you first arrived?
We were summoned into the building by the Rochester Police Department because they arrived on scene to clear the scene for us first. For our safety, as is standard with all reported assault calls. Entered the building where the patient was found, talking with the police officers.
Okay. And did you make any observations of her at that time?
She appeared to be tearful and crying, as well as upset at the time.
Did you identify who she was?
I did.
And who was the patient?
I cannot remember the last name. I have to review my run report again.
I showed you a copy of that report. What was her name?
Erin McCarthy.
Fair to say you respond to a lot of scenes in Rochester as a paramedic?
Yes, sir.
So you respond and you go inside Planet Fitness and you make contact with her and she appears tearful and upset?
Yes, sir.
Okay. What is the first thing that you do when you make contact with a patient with the information you have?
The first thing I do is introduce myself, my name, and my title. And I ask the patient what had happened.
Okay, I'll stop you right there. What is the purpose of asking a patient what happened?
It's for us to gather information on possible injuries or complaints that's related to why we've been called. It gives us a detailed history of events that transpired prior to our arrival.
Okay. Does it help you make any decisions with regards to that patient?
Yes, sir.
And what decisions does it help you make having that information?
It gives us an idea of possible injuries, as well as gives us a baseline of the patient's mentation from events that were transpired.
Did you have that conversation with Ms. McCarthy?
Yes, sir.
Did she provide you with information about what happened?
Yes, sir.
What did she provide you at that time?
She said that she was walking out to her vehicle at the end of her shift. And as she was approaching her vehicle, she was assaulted by an unknown party.
So she indicates that she had been assaulted. Did she tell you where she had been assaulted?
She said that she was struck multiple times in her head.
May we approach briefly?
Yeah.
So, Mr. Gagnon, you have information that this person has been struck in the head. Do you conduct an assessment of her at that point?
I do.
Okay, can you walk us through the sort of head-to-toe assessment of what you are doing in relation to her body?
The first thing I check is the patient's level of consciousness and mentation, which is usually obtained by asking questions about the events that transpired prior to our arrival. And then I briefly examine the patient, mainly looking for any obvious injuries, any visual injuries, as well as any symptoms that the patient describes.
Okay. And what symptoms, if any, did Ms. McCarthy describe?
She described a headache, however she was unable to provide the quality of the headache or a specific location. It's described as a diffuse headache, as well as pain to her face in the areas of the observed injuries.
You said the term diffuse headache?
Diffuse.
What does that mean?
The spread throughout. So unable to pinpoint an exact location.
For her entire head?
Correct.
And you said one of the things you do while you are assessing her is you look at physically any injuries that she has on her body.
Correct.
Okay, can you tell the jury what injuries that you specifically observed?
They observed a small hematoma, which is blood collection under the skin, near the left eye, as well as on the left forehead. A small laceration under her left eye that has a small amount of bleeding, and small abrasions to her left hand.
And after observing all of those injuries, did you provide any treatment to Ms. McCarthy at that time?
I had given her gauze for the laceration that is under her head, or under her eye, excuse me. And recommended that she proceed to the hospital for further evaluation, as she did not want to be transported with us in the ambulance at that point.
With regards to the head injuries that you had observed, did you treat her for those at all?
There was no treatment required on the scene, as it requires more detailed medical imaging from at the hospital for its viewing inside the head.
You can't see on the inside of the head when you're standing on the side of the
Correct.
evidence, right? And you said that you had recommended that she go to the hospital?
Yes, sir.
Mr. Gagnon, those are all the questions I have for you. You've met Attorney Durkin. You might have some questions for you, okay?
All right, cross-examination.
Thank you, Judge. If I read your report correctly, you arrived about 11 minutes after 10.
Yes, sir.
You were dispatched 3 or 4 minutes before that.
Yes, sir.
And when you get there, you do see Ms. McCarthy, right? She's talking to the police.
Yes, sir.
And she's standing up.
Yes, sir.
And she's standing up on her own without any help from anybody else, right?
Yes, sir.
And she's talking to the officers, right?
Yes, sir.
Presumably telling them about what happened.
Correct.
And you did a medical examination, right?
Yes, sir.
And you determined in that medical examination that there was no loss of consciousness?
She did not report any loss of consciousness to me.
And that's typically how you would determine whether there's a loss of consciousness, right?
Correct. Asking the patient if there's any lapse of time, if they any, as we call it, blacking out, or as well as asking bystanders if there's loss of consciousness.
And there was no indication of any loss of consciousness?
At this point, no, sir.
There's something in your report about a Glasgow coma scale, right?
Yes, sir.
And there was a rating of 15. 15 is the best, right?
Yes, sir.
So hopefully what you and I would have right now is a 15.
Correct, sir.
Here in your report, you indicate that she was alert to people, place, and time, right?
Yes, sir.
And that her neurologic exam was normal,
Yes, sir.
and her pulse was normal,
Yes, sir.
and her breathing was normal,
Yes, sir.
and her pupils were normal.
Yes, sir.
She didn't have any vision changes.
Correct.
She wasn't experiencing any nausea,
Correct.
no weakness,
Correct.
no dizziness,
Correct.
and no numbness.
Correct.
These are all things you were looking for.
Yes, sir.
And there was nothing of note in regard to her neck, right?
Correct.
Or her chest,
Correct. She had no complaints for her neck, chest, abdomen.
or back.
Correct.
And I think the treatment that you provided was a piece of some gauze for the small laceration under her eye.
Yes, sir.
Thank you, Mr. Gagnon.
Thank you. Any redirect?
Mr. Gagnon, despite all of those negative findings, you told us you still recommended that she went to the hospital, correct?
Yes, sir.
No further questions, thanks.
Thank you. Any recross?
That's who you work for, the hospital?
Yes, sir.
All right, sir. 5 minutes.
State restaurant.
All right, ladies and gentlemen, so what you've heard Attorney Sullivan state is that the state has rested this case at this time. What that means is the case in chief is concluded. What I am going to do is have you take a short break into the deliberation room while I discuss with the attorneys the next steps in the case, and then we'll have you back in the courtroom shortly.
All right. Please be seated. Attorney Durkin.
Judge, the state having rested its case, we move to dismiss the felony charge only, the felony of second-degree assault, because no rational juror could find on the evidence presented that this was a blatant disregard to life. That means, really, when you look at it, the state would have to prove that Mr. Lamonde had a blatant disregard to whether or not Erin McCarthy would have survived her life as a result of this incarceration. Let me first address the planning issue. The planning is a red herring. It's irrelevant to the analysis here, because you can have all the planning in the world you want for a misdemeanor, but it doesn't make it rise to the level of a felony. You can plan for 6 months to shoplift a piece of bubble gum, and that doesn't make it anything more than a petty misdemeanor. The facts in the light most favorable to the state here are no weapon was used. No gun, no knife, no blunt object whatsoever. This encounter ended after 28 seconds on Mr. Lamonde's own initiative, without the intervention of police, without the intervention of a third party. There are plenty of cases to talk about, I'll talk about that in a moment, where the Supreme Court says this was extreme indifference to the value of human life because, but for this intervention, death could have occurred. That's not the case here. There's nothing. There's not even not just someone, there's no one pulling him off of Miss McCarthy. There's no one driving up. There's no one spooking him. There's no one scaring him. There's no external force exerted whatsoever on Mr. Lamonde to end this encounter. There's no serious injury. You heard about the injuries. There are some, what we qualify as bodily injury only. You didn't hear about any treatment for any injuries. The only treatment we got was a piece of gauze for a superficial laceration under her left eye. The state didn't present any expert testimony here. There are cases where talk about expert testimony. The state could have called a doctor here. Apparently, Ms. McCarthy went to the emergency room. Presumably, she was seen by a doctor there. Had the state wanted to, the state could have called a doctor to testify that this type of injury or this type of assault could have led to death, or what risks was associated with that. The state elected not to do that, and that's an inference that can be held against them. We also don't have any verbal threats. Some of the cases talk about verbal threats to kill. There's no verbal discussion whatsoever. This is not a situation where the encounter stopped and then was reinitiated, either moments later, hours later, or over the course of weeks. He left and he never returned. And this does not involve multiple assailants. The cases that our Supreme Court has discussed sufficiency regarding extreme indifference to the value of human life, there are not many of them, but they all contain facts that are way, way above and beyond the facts that we have here. And the reality is these cases present a very narrow, cases that qualify for this theory of second-degree assault are frankly very narrow. There are, when you don't have serious injury, when you don't have a deadly weapon, and really it's a situation is, we avoided death here by fluke is really the issue. And that's just not the facts in this case. Let's take a look at the facts in State versus Fletcher for a moment. 129 New Hampshire 641. The victim there was the defendant's 62-year-old mother. The defendant repeatedly jumped up and down on her chest, her head, and her back. Outside interventions stopped the progress of the assault, and the Supreme Court found that if that intervention hadn't happened and that assault continued, death would likely happen. Let's look at State versus Edson, 153, New Hampshire 35. The defendant was a Golden Glove boxer. The victim, as a result of his blows, lost consciousness. He kicked her in the stomach between 4 and 6 times. She was wearing body armor, and the court found that that body armor protected her from death from those blows. The defendant left her dizzy, sick, disoriented in a snowbank, presumably it was cold, in a remote location. State versus Saucier. The defendant choked, grabbed by the hair, dragged her across the parking lot, picked her up and threw her across the lobby, hit her head with the door, released her, and then pursued her again, where he was finally separated by the police. Your Honor, will give me a moment. I have to find one other portion of this argument. In State versus Allward, 164, New Hampshire 52. The defendant put a sock in the victim's mouth. There were multiple assailants involved. Tied her up with bandages and cords on her ankle, wrist, and neck, and used a tool to try to rip out her tongue. Those are the cases, Your Honor, where our Supreme Court has found that the state has met its burden of showing extreme indifference to the value of human life. They all involve one or more substantially aggravating factors that do not exist in this case, where we have no weapon, we have no prolonged assault, we have no expert testimony, we have no external object used. There's no choking, there's no intervention by a third party that ends it. The other case, Bailey, that was a baby case. I think the baby was 11 months old. Expert testimony was brought in by the doctor to say, this is the worst case of child abuse I've ever seen. And if this had continued, and it had gone on for weeks already, if it continued, the doctor offered the opinion that this would result in death. And we don't have any of that here. What we have is a simple assault, or perhaps even a series of simple assaults. And maybe there's some sentencing factors or some enhancement regarding sentencing for some of those things. But the planning doesn't make it a felony, and none of the other facts rise to the level of felony. It's a simple assault or multiple simple assaults, but it's not second-degree assault.
Thank you, Attorney Sullivan.
Thank you, Your Honor. Your Honor, I want to start with talking about State versus Edison, which points out that whether a defendant charged with second-degree assault acted with extreme indifference to the value of human life is a question of fact for the jury to decide. The defendant, in his analysis, points out to all of these cases where the Supreme Court has said, this is enough. That doesn't mean this scenario here doesn't rise to that because it has different facts. And where the states would point the court to specifically to demonstrate that the blatant disregard that the defendant demonstrated to the life of Ms. McCarthy is first the initial strike. As the court has seen, he had every opportunity to approach her from the front. He chose specifically not to do that. He chose to come up behind her when she was the most vulnerable, when she had her guard down, and when she was struck in the side of the head, which, as the court has seen in the video, he increases his speed right before he does that, getting his entire weight of his body into that punch. He knows the two cars are there. He knows he's standing on pavement. He's certainly aware of the risk of knocking her out, falling to the ground, which can cause serious bodily injury. But that's, again, we don't need to demonstrate The injuries are a red herring in this case because the law is that the injuries themselves are not required to be life-threatening. She could simply have a scratch. She managed to get out of this vicious assault with just the scratches and some bruising, but that's not the analysis here. The analysis is in the light most favorable to the state, whether or not he demonstrated a blatant disregard. The defense keeps pointing on this fact that he ended the assault. Well, he also kept it going. And after he first struck Aaron in the back of the head, he continued to unleash a fury of punches, every single punch directed at her head and face. Then,
I'm going to object to that. That's not the evidence, and you can see it on the video. While there are some punches that the video depicts as going to the head, they're not all directed. You can see the evidence yourself. That's a mischaracterization of the evidence.
it's absolutely not. It's what the video shows, Your Honor. And what it shows is he's directing towards her head and face. She might block some of them, but that's where he's aiming. And when he's not successful in getting her to the ground, he picks her up over her shoulder and smashes her onto the ground. Again, onto pavement. That moment, again, knowing she's going to hit her body, which includes her head, on the pavement. When that's not enough, he then grabs her, and while he's holding her, as she staggers to her knees her directly in the face. Not once, but twice. And as she goes back, he unleashes a final left hook right to her face. He continues to beat her, and it's at this point his sunglasses go flying off. His identity revealed is when he pushes her to the ground and leaves. So this suggestion that because he didn't use a weapon or because he ended the assault on his own, that somehow impacts the analysis is simply inaccurate. The state has certainly, in the light most favorable to the state, presented sufficient evidence. Officer Marvin testified that when she felt the back of the head, the lump, her concern was that she had potential brain bleeding, which she knows could cause death. That evidence is in. The jury heard it. The jury can consider it. Mr. Gagnon also testified about the injuries that he observed and about the fact that he sent her to the hospital. This suggestion that she didn't receive treatment is not true. Ms. McCarthy testified she received treatment in the form of a CT scan, that she was tested and ultimately released from the hospital. So for all those reasons, Your Honor, again, looking at some of these cases, again, I acknowledge that they're really, really bad. That doesn't make it that this isn't really bad either. And in fact, Marbury talks about how the defendant had been punched in her face and head repeatedly, continuing to do so even after the bleeding began, and that's what the court found was sufficient. There was testimony from the treating physician about the repeated blows to the head, but again, looking at the acts themselves, the court found that was sufficient to demonstrate extreme indifference. So the state, at this point, would suggest in the light most favorable to the state, we have satisfied the state's burden.
Attorney Durkin, anything further?
No, Your Honor.
All right. After consideration of the motion is denied. As the parties know, the court must take the evidence in the light most favorable to the state at this juncture of the case. Our Supreme Court in second-degree assault extreme indifference cases has repeatedly stated that whether extreme indifference exists is a question of fact for the jury. In this case, there is sufficient evidence in my judgment to allow it to go to the jury based on the number and location and severity of the punches, the conduct in kneeing the victim to the face, throwing the victim to a paved surface, and taking into account as well that the initial blow appeared to be completely by surprise and from behind to the head. Those circumstances a jury could find extreme indifference. So the motion is denied. Attorney Durkin, are you presenting any witnesses or do you need time to consider that issue?
Defense rest.
Do you wish to rest in front of the jury?
No.
Or I can simply inform them of that when they come back to the courtroom?
You have our permission to do that, Your Honor.
So why don't we just take a few minutes, I'll get the final set of instructions. I've made the changes that we talked about in chambers and on the record. I'll give you each a set. It's 11:35. How long would you expect closing to take from the state's perspective?
Probably 20 to 25, maybe 30 minutes. I think 30 is probably long, but...
Okay, defense counsel?
15 tops.
All right, so probably what we can do then is get the closings in before lunch and then charge after lunch. Are you okay with that? Or would you rather that the charge come right after the closings?
I'd prefer that the charge comes after the closing, so if we do have time to get it in before lunch, I'd appreciate that.
That's what I'm saying.
We'll do the best we can. All right,
Thank you,
great.
Judge.
Let me get the instructions and then we'll be ready to go.
So we have about 10 minutes or 5 minutes?
It'd probably take me 10 minutes to
Okay.
finish them up and to get copies, so
Great.
go ahead and get yourself set up.
Thank you.
All right.